Do you know what copyright is and how does it work? Let's see.
Look at the stars, look how they shine for you, and everything that you do, and they were all yellow. I came along, I wrote a song for you, and all the things that you do, and it was all yellow. Oh, your skin, oh yeah, your skin's and bone turning into something beautiful. You know I love you so. You know that I love you so.
I'll be back
넌 다시 나를 찾을 거야. 그때 다시 내가 올 거야. 그 누구도 너를 나보다 사랑할 순 없기에.
Stop! Before you start fighting, you first have to understand what copyright really is. Do you know that whenever you write a poem, a story, or even a paper for your class, or when you create any other kinds of drawings or artworks, you automatically own the copyright to it? Copyright is a form of protection given to the authors or creators of original works of authorship. If you are a copyright owner, you will own all or any of the exclusive rights, and you may prohibit others to do any of the following. First, make copies of your work, distribute copies of your work. This could be perform your work publicly, display your work publicly, and make derivative work.
Oh, but for my case, it is about musical works. Is musical work protected by copyright?
That's a good question, Han. Copyright-able works fall into many categories, including
as you say, copyright had to be original works of authorship. What does it mean? I don't understand why.
That is an interesting point. So your question is that, why is it important to require that protected copyright works must be original, right? Well, there is no exact meaning of originality because the law gives a wide interpretation of the word. However, it has to consider copyrightability. The work has to meet at least some minimal degree of creativity or possess some creative spark, even if it is unintentionally identical to an existing work. Here are the following reasons why copyright works must be original. First, to give priority to authors who think and done it first. Imagine that you came up with an invention. Wouldn't you be proud of it since you spent a lot of time and effort in initiating this new creation to the society? You then deserve to have the privilege to control what people can and cannot do with your work. Second, to prevent others from appropriating that which is considered inherently unoriginal. For example, if you are a talented musician, you deserve people's respect and appreciation for your works. However, if others can copy your work and get financial benefits from it, you will no longer want to produce any more work, do you? Third, to protect works that are too similar to existing original works. If the work is closely similar to the originator, originality is required to protect the originator. And last, to encourage invention in new works and innovation for a better standard of living in the society. For example, the more advanced technology or innovation, the higher growth rate of the country will be.
Now, I understand why copyright work has to be original. I'm sure that my song is original, so it should be protected, right?
To be copyrightable, there's two requirements for the copyrightability. First, originality, as I have said before, and second is fixation. Fixation is to record the works in some form. For example, a song that has been created and performed but has never been written out in sheet music or recorded has no copyright. Ultimately, copyright law protects the expression of an idea but not the idea itself.
Why the law focus on the originality of the form? How does it implement?
That's a good question. But to know why the copyrighted work should be expressed in forms, let us first look at the cost of protecting the ideas alone. First, it will be impossible for the law to prove the origins of the ideas. Second, there will be an excessive number of ideas but no real improvement and development in practices. Third, it will be difficult to tell the world what the law is actually protecting. Fourth, there will be no free flow of information or freedom of thought, because if one thinks of an idea, the others cannot think about it anymore. And finally, when too many things are protected, the world cannot get so much benefit from it. Now, we will see why the expression of an idea is important by focusing on economics, legal, and social viewpoints. For economic viewpoint, first, to easily identify the owner of the creative works who deserve to get the financial benefits from the publications of the work. Second, to protect skills and labor devoted into creating the work and not just thinking about it, because there are always an opportunity cost for doing the other things. Third, to create incentive and encourage authors or producers to produce new creative works, which can improve the standard of living in the society. Fourth, to allocate resources efficiently and fairly in terms of work and money. For example, the law may be preventing the excessive number of protection or giving monopoly power to the people who only think of ideas but put no effort in making it real. In addition, there is a concept of marketplace of ideas. That is, if we allow ideas to be available together and compete, the market will work itself. Then, the best creation will emerge. And now to the legal viewpoint. First, to be able to tell the world what the law is protecting, because the idea itself is abstract and non-tangible. Second, to give power to the right person who has the evidence of authorship. Third, to meet fewer arguments and lawsuits. And finally, to the social viewpoints. First, to give the opportunities for people to actually put effort to make the ideas resourceful, or else it will be the waste of resources. Second, to allow free flows of information and encouraging further creativity and freedom of thought. Third, to obtain real development or improvement in the society, because the public gets nothing if people only speak. And fourth, to clarify existing copyrighted work, because if the idea itself is protected, people are unable to know the thoughts of others, and this leads to the complexity in creating the new work. So, we can now conclude in the simplest form that copyright laws only protect something solid and that are expressed in forms. People who thinks first of an idea doesn't matter, while people who produces it first gets the privilege in getting protected. As for Han, I am very sorry to say that you will not be protected in this case, even though you claim that the song was yours. This is because you have no proof that you are the originator of it. From now on, be sure to always write down your musical notes or record it in some forms if you don't want your ideas to be stolen again. Remember, copyright laws protect the expression of idea, but not the idea itself.